Why is Sarawak only now challenging the legality and constitutionality of the laws which were put in place shortly after the formation of Malaysia? Surely our founding fathers knew fully well what they were doing.
Former Law Minister Zaid Ibrahim has dismissed Sarawak's claim that its territorial boundaries were extended prior to the formation of Malaysia. Speaking to FMT, he says Sarawak appears to have misunderstood the difference between exploitability, the right to extract resources, and territorial limits, which define the boundaries of a state.
The Sarawak Alteration of Boundaries Order in Council 1954 and the Geneva Convention on the Law of the Sea 1958 dealt with where and what could be mined, which is known as exploitability. It did not deal with what was or was not part of Sarawak, which we refer to as the territorial limits. These two concepts cannot be conflated.
He said the Oil Mining Ordinance 1958, cited by Sarawak, only granted exploitation rights. However, the Petroleum Mining Act in 1966 later repealed the OMO as regards the exploration, prospecting, and mining of petroleum offshore. Zaid said the Petroleum Development Act in 1974 went on to centralize oil and gas ownership under Petronas. Last week, Sato Assemblyman Ibrahim Baki told the Sarawak State Assembly that the OMO remains valid, giving Sarawak rights over all oil and gas resources on the continental shelf, a view which has been reinforced by Sarawak Premier Abang Johari Openg. Zaid, however, called those claims and assertions misguided and disingenuous.
The offshore effect of the Oil Mining Ordinance was repealed by the Petroleum Mining Act 1966, and the onshore effect had been appropriated for consideration under the Petroleum Development Act. There was nothing left to repeal. The legal position on this issue is as clear as daylight. It could not have dawned upon anyone only now.
Danish Rajareza, FMT News.